I've been handed a document indicating that Mr. Fleener is going to enter a plea of guilty to the charge of violation of probation, waive his hearing, be reinstated to probation for a term of 11 months and 29 days. The last 6 months are supposedly going to be unsupervised if all conditions are met and probation officer agrees to the remaining term to be unsupervised. He's ordered to pay the court costs. May I see this? This is a misdemeanor probation.
Yes, Your Honor.
Mr. Fleener, raise your right hand. Let's place you under oath. State your full name for the record.
James Larry Fleener.
Mr. Fleener, you are here today on a charge of misdemeanor probation violation. You've heard me go over what your lawyers worked out with the state, but do you understand that you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation? You understand you would have the right to have a lawyer and to have one appointed if you cannot afford your own. You understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by pleading guilty, you're waiving your right to a hearing and to an appeal. All I'm going to do is approve what your lawyers worked out. You understand everything I've explained?
Yes, sir.
Do you want to plead guilty according to this agreement? Then I find you guilty of violating your probation and reinstate you to probation for a term of 11 months and 29 days. The question of whether or not those last 6 months will be unsupervised will be up to the probation officer. If they agree that your situation can be unsupervised, then I will allow that. So, see the probation, please.
Thank you, Your Honor.
Your Honor, for Mr. Davis, there's a pending evaluation to be completed still, so we're waiting on the results of that. My suggestion is to reset this to the next BOP day.
And we're talking about October the 27th?
Yes, sir, please.
Right, October 27th.
Thank you, Your Honor.
Mr. Wainick, on page 10 of the docket, we have State versus Eugenia Yvette Frazier.
Judge, we do not have an agreement on this case, so we either need, I guess we need a trial date.
Right. How about October the 8th? You what?
I might could win it then.
Well, I have a vehicular homicide case in Humphreys County that had to be continued, so it opened that day up. How long do we expect it to take to try this case? General, do you have any idea on time-wise?
I can't imagine it going more than 2 days.
More than 2 days?
No more than 2 days.
I set the State versus Carol Hughes on the 26th of March. That's a case that, as far as we know, is going to go.
I did one last year on that day, my birthday. Might as well keep it
Oh,
going.
have we broken the news to,
Wait a minute. No, something's going on.
what about April the 8th and 9th?
Works for me.
April 8th and 9th. I know that's in somebody else's term here, but I'm in Stewart County, may be able to move. All right. Ms. Frazier's case will go to trial. She'll either have to plead to every count of the indictment and go to sentencing, since this is her last plea day, or she'll go to trial. And that trial will be on the 8th and 9th. We need to notify that the Stewart Chancery will be moved to the 10th.
Thank you, Judge.
Judge, up next is
Okay.
Morning, Mr. Dawson. Okay, excellent, good. Do you want me to keep this? Your Honor, do you want me to take this? Your Honor, for Mr. Dawson, there's some discussion of working out a furlough for Mr. Dawson to attend treatment, and we would like to have time to do that. Therefore, we would ask for this to be reset to the October 27.
October 27th.
Thank you, Your Honor. Thank you, sir. I appreciate it.
Moving to page 12, State versus Seth Ryan Hall. Mr. Brown, we'll do it when we bring him back. Sorry, Mr. Brown, go ahead.
Judge, this case has 3 co-defendants. Last week, Mr. Spratt asked that we set them today. He intends to file a motion to suppress and wanted to pick a motion date.
Anybody see Mr. Spratt anywhere in the courtroom? Look under the table. There are 3 defendants. Who are the other?
There
Mr.
we go.
Massengill represents one.
It's like a
Mr.
clown
Spratt
car.
represents one. All right. Mr. Spratt, we have an anticipatory motion to suppress,
Do, Your Honor.
not yet filed.
It's not yet filed. At the arraignment hearing, Ms. Lowe was appointed to represent Mr. Dubois. Judge Wallace was not aware whether or not Ms. Lowe was taking appointments yet. So, and it's an idea that I actually got from Your Honor. I asked if I could be elbow counsel. And in the event that she needed some assistance or didn't want to take certain
This is
appointments.
the same case.
It is, Your Honor, and so I'd asked that Ms. Lowe has had some issues and has had to step away, so I'd asked that I have an order entered. My order right now says that I'm co-counsel, so I just
All right,
asked.
so we just need to make you counsel number 1.
Yes, sir, and then I do anticipate filing a suppression. I
Call
just,
an order that shows that the court finds that you should be designated as the attorney appointed to represent James Thomas Dubois. Now, with that being the case, we have Mr. Brown and Mr. Massengill who are representing the co-defendants, and I'm trying to determine, it was stated that you were planning to file a motion to suppress and needed a motion day. I just need to find out if you want to go ahead and set a motion hearing date.
I guess just when in the ballpark would we be looking at? I looked at Ms. Lowe.
I get the feeling that you haven't filed it yet, and from what I know about spinning plates on a stick like most lawyers have to do, the question is, how much time are you going to have to get ready for this motion to suppress before it has to be heard? Is that the issue?
Well, it's been drafted, and I looked at it last night. It needs I'm gonna need to do some work on it, so I don't know if I could.
I'd like to ask for sufficient time, though. I mean, if there's no objection from the counsel for co-defendants, I just came on this thing, Your Honor, with the order for appointment in July. Review discovery, I've met with Mr. Perry, but I'd like to have time to work with Mr. Spratt to kind of coordinate in case I'd like to join in on that motion, though, Your Honor. So if there's a motion date further out, I have no.
Further out means different things to different people. So, so further out to me means next month. How much does further out mean to you two?
I think I was leaning Mr. Massengill. That's the reason I asked about the ballpark earlier.
I didn't hear Mr. Massengill say how far out.
Is January, is there any availability out in January, Your Honor?
We have motions set, several motions that are already set on the 9th, right, of January. Joshua Garden, and we have the Hansard motion. It sounds like a full day already. We have the State versus Butcherelli that's set for the 4th of February through the 6th, right? Yeah, that's what I was looking. February 27th. That's 5 months away. You think you can get everything ready by then?
That work.
And do we need to go ahead and, I guess on that day, depending on my ruling on your motion to suppress, we'll talk about setting it for trial. State have any problem with that February 27th date? I need to check with them.
Judge, that will work for me.
All right, so this is the State versus Dubois. Who are the other defendants? Perry,
Billy Ray Perry, Your Honor.
Seth Hall.
Thank you, Your Honor.
Right. You just bring him up. We have Mr. Dubois, Mr. Spratt. Mr. Dubois is here, so let's bring him out and let him know what's happening. So. All right, Mr. Dubois, your lawyer has indicated that, number one, I'm going to appoint Mr. Lee Spratt as lead counsel in your case so that he's a lawyer with a good deal of experience, so he'll be the lawyer representing you. And he has indicated he needs to file some motions in your case, and some of those motions could potentially be dispositive of some issues, so I'm going to give him the opportunity to do that. In order to do that, he indicates he needs considerable length of time, so we've reset your motions for February the 27th. Talk with Mr. Spratt, let him explain to you what he's doing, and then we'll come back to you on February the 27th or earlier if y'all work something out. So. All right. Who else we got? May take up while we're waiting on that person. State versus Donald Eugene Helms, Mr. Atchison.
Judge, I believe Mr. Helms is on for status. He had a doctor's appointment on the 22nd, so we moved him to the 29th. He's present. I believe Mr. Helms just needs a trial date, Judge.
All right. Who's the prosecutor?
General Wolfe now.
All right, so we need a trial date. How long do we think it'll take to try? And your client understands that once we set a trial date, he's going to trial or he's pleading to the indictment and going to sentencing.
Yes, Judge.
All right, the last chance today to make a plea agreement. Any indication, General, on 2 days? What about the th and 15th of May or the 28th of May? We've got State versus Anthony Thompson that is indicated would be a 1 to 2 day jury trial on the possession of a firearm during a commission of a felony.
That works for me, Judge.
So we're going to set it on 21st day of May, 14th and 15th. All right. So this is State versus Donald Eugene Helms. And you were saying it could take 2 days, correct? All right, 14th and 15th of May. You'll go to trial or plead to the indictment. Who else do we have ready?
Thank you, Judge.
And Marcus Pace.
That's gonna be for plea, but I believe we're gonna I do know where he's at now. They moved him, so at least we can talk.
Well, you're looking at May. How long will it take to try Mr. Hogan?
You think too?
3 days? What about June the 3rd, 4th, and 5th?
I'm good with that. You're not going anywhere, are you?
I ain't going nowhere. No time soon.
Hogan said he'll be available. This gentleman here was nice enough to.
That's it.
That's it, Judge. Thank you.
All right, we're going to take a recess. I'd like to see all the lawyers and prosecutors in the jury room across the hall, please.
All rise. Court is now in recess.
I wanted to kind of talk through some scheduling issues that have arisen, and we'll now go back to who's the next person we have. Oh, I'm sorry, Mr. Helms.
Judge, I just wanted to revisit Mr.
Donald
Helms.
Eugene Helms, and we're going to set you a new status day, is that correct?
That's correct, Judge. The January status. date.
January 7th. We are deleting the trial date and setting a new status day. Nope, it will just be status.
Thank you, Judge.
What's happening is, for your information, is that the people who are, all right, Mr. Dawson has a second amended violation of community corrections, and let me hand a copy of that to Mr. Howard. Mr. Howard, do you wish a formal reading of that? October 27th. Yes, they are appointed on the second amended violation of community corrections on 111. All right, Mr. Friels is charged here on a criminal information. Mr. Wainick, you represent him?
I do, Judge, and we have a, we have a plea worked out.
All right.
I just need him to sign.
All right. Thank you.
Judge, this is a criminal information. It's a 3-count. There's 3 charges. Pursuant to the agreement, Mr. Friels will plead no contest. Will plead no contest. And on count 1, that is a DUI first offense. He'll receive 11 months and 29 days in the county jail. That is to be served day for day. He'll receive a $350 fine plus court cost. He will have his license restricted for, well, he'll have his license suspended for 1 year. He'll be eligible for a restricted license. He'll have to have an alcohol and drug assessment and complete a victim impact panel. He will, count 2 is reckless aggravated assault. He'll receive 12 years suspended to community corrections. That is consecutive to count 1. Count 3 is felony felony evading, and he'll receive 6 years. That will be consecutive to count 2. Concurrent to count 2, excuse me, for a total of 12 years suspended community corrections after serving the 1129 on count 1.
All right, Mr. Friels, raise your right hand. Let's place you under oath. Thank you. State your full name for the record.
Joseph Matthew Friels.
Mr. Friels, you are here today on a criminal information. I want to make sure you understand what that means. Every person who is charged with a criminal offense carrying the possibility of incarceration has the right to have their case and the evidence against them reviewed by the grand jury of the county where the offense is alleged to have committed. The grand jury is an independent body that reviews the evidence and determines whether there's probable cause to return a formal charge against an individual. You have the right to waive that step and expedite the entry of a disposition in your case. And by doing that, you sign off on a criminal information. I've been handed a criminal information that indicates that you wish to do that. Is that correct?
Yes, sir.
All right. And you understand that he needs to sign off on the waiver of his indictment and criminal information. So he needs to sign it. You need to sign it as well, Mr.
I apologize for
Winnick.
what I did. Oh,
Well, I'm sorry, there was a waiver of indictment signed by the two of you. Never mind.
We need to
We have
sign
a
this?
signed indictment. I was given a copy of that and it did not have the signatures on it, so. All right. Mr. Friels, I've also been handed a document indicating that you want to enter a plea of nolo contendere, which means no contest to those 3 counts that Mr. Winnick has gone through. Do you understand that means you're not going to admit you did anything, but you're not going to contest the state's evidence? And I will then hear from the state about their evidence, and that evidence will support a finding of guilt in your case. Do you understand that?
Yes, sir.
You understand, however, that what you're charged with, and if you and Mr. Winnick had an opportunity to discuss the range of punishment you're facing as well as any possible defenses you might have to the charge.
Absolutely.
Well, it's indicated that you want to enter this plea of no contest. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand that if you went to trial, you'd have the right to have a lawyer and to have one appointed if you could not afford your own.
Yes, sir.
You understand that if you went to trial, you'd be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that you would be presumed to be innocent at trial. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
I do.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading a no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers worked out.
Yes, sir.
Do you understand that's going to result in several convictions that are going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime?
Yes, sir.
You understand everything I've explained to you?
Have.
Do you want to plead no contest according to this agreement?
Plead no contest.
Is your decision to plead no contest today voluntary?
It is.
Anybody forcing you to do this against your will?
Sure.
You understand I cannot accept your plea unless I'm satisfied that you are guilty and there are facts to support it.
Do you understand?
And I want you to listen as the state tells me what their evidence would be if this case went to trial. Step aside for the district attorney, please.
Your Honor, if this were to go to trial, the state would intend to show, we'll start with count 3 since it's the older in time. On or about July the 8th, 2023, Officer Brent Allen with White Bluff Police Department observed Mr. Friels get into his F-150 truck after exiting a convenience store in White Bluff, where he knew Mr. Friels to have a revoked license. Officer Allen came up behind Mr. Friels on the road and activated his lights for a traffic stop, but a pursuit ensued instead, with Mr. Friels going into multiple lanes of traffic. Officer Allen did terminate the pursuit due to safety concerns. These events did occur in Dixon County. For purposes of counts 1 and 2, on or about June 3rd, 2025, Trooper Dyer with Tennessee Highway Patrol responded to a wreck with injuries at or around 3408 Trace Creek Road in White Bluff, Tennessee, here in Dixon County. An investigation determined that Mr. Friels had operated an F-150 at a high rate of speed in the wrong lane and did strike a car driven by Ms. Stephanie Robertson head-on. After this initial impact, Mr. Friels then pulled forward and struck her again. Mr. Friels then came up to Ms. Robertson, who was stuck in her vehicle, and told her to tell the police his grandmother had been the one driving the car, and then subsequently ran off. Ms. Robertson and another witness on scene did observe Mr. Friels to show signs of impairment from illicit drugs. Ms. Robertson was able to identify Mr. Friels in a photo lineup. Trooper Dyer did locate a suspected meth pipe and THC wax in the vehicle, and Mr. Friels abandoned on scene. Trooper Dyer was able to call Mr. Friels on the phone. Mr. Friels stated he had gone to Vanderbilt for his injuries, but Vanderbilt reported Mr. Friels had never come to any of their facilities. Ms. Robertson did sustain injuries in this matter, which is the basis for the reckless aggravated assault. Just for the record to note, under 4035-501cc, the reckless ag assault is 100% should he violate community corrections. I know that he's been told that by counsel, but I just want to make sure it's noted on the record. The state also notes that Mr. Friels is to have no contact with Ms. Robertson as part of that community corrections. Mr. Friels is a career offender, and which is why he is receiving the sentence that he is receiving. Ms. Robertson is aware of the settlement and is here today. She has approved this settlement, and she is here to read off a statement that she has written in this case.
Now, Mr. Friels, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
I do.
Are you satisfied with your attorney's services? Do you believe that Mr. Wainick has done a good job of representing you competently? All right, Mr. Wainick, do you know of any reason you should not enter the plea?
I do not, Judge. I do want to add one thing, though. I was appointed to this case in general sessions. We worked out the criminal information there. That's why I'm announcing that here. The charges in general sessions are to be dismissed after he enters his plea.
All right. Then, Mr. Friels, you and Mr. Wainick have a seat over here and let the victim impact statement be made, please.